Yeah.
we're starting to get some questions. I'm going to go to them in a minute, but I got another question for you. So, what if a cop asks you to blow, or what if they ask you to, meaning breathalyzer, or what if they think that you're imbibed or drinking or on drugs or something and ask for a blood test? What do you do then? I mean, this you probably get. Is this the question you get the most?
Yeah. So it's not 100% that simple. You know, if you have never been charged with a DUI before, especially in Missouri, if you feel like there's any chance of you producing a breath test where you blow over 0.08, if you feel like it's at all out there and at risk, you should absolutely refuse. The difference is if you do refuse and you end up taking probation in the criminal case, we can get something called a confession usually. So you will not ever lose your license.
What's that called?
It's called a confession. So there's two sides to the DUI. In Missouri, there's the criminal side, which is whether or not there's jail, probation. And then there's also the civil side with your driver's license. If you don't blow in the breath test and it's your first offense and you're respectful to the officer, you can end up not losing your license at all, not having to change your insurance. You know, on the other hand, for instance, if you have a prior DWI, let's say you've already had a DWI, it resulted in probation, you got the confession. If you're pulled over another time, the only way, if they think you're drunk, the only way you're going home without a DUI charge is to blow under 0.08. And they're going to charge you if you don't blow, and they're going to charge you if you blow over. So I always say in that situation, stall it out if you think you can get yourself below that 0.08. Actually exercise your right to a lawyer. Actually call one. Tell them you don't want to produce a breath test there. You want to go to the station. Time is everything. You can generally digest one cocktail or one beer per hour. Buy yourself as much time as you can, and you have to make that decision. If you want to pay a lawyer 20 grand to try your case and there's no negotiating, then yeah, don't blow. But you know, if you're not going to go home without a DUI charge unless you blow under in that situation. So
if you go and try it and beat the rap, does that help you on the civil side?
There's different standards. I've had clients where they got, for instance, there's this one gentleman who was intoxicated driving on the highway, and he was very intoxicated, and he's like, hey, I don't know what I'm doing here. I got to pull over. This is dangerous. He pulls over. The police came up. He had his key in the ignition, and they charged him with a DUI. They chose to drop the criminal charges. The prosecutor saw that he was correcting his behavior. They dropped the criminal charges. That did not help him on the license side. They don't need to prove that you were driving intoxicated beyond a reasonable doubt to suspend your license. It's a much less of a standard, and it can help either way, but usually those are just seen as distinct matters.
All right, so let me see if I got it right. If you've never had a DUI, you should refuse to blow. If you've had one before, you should say, I want to do it at the station, or ask for it. What about asking for a blood test or delay it as much as possible?
You want, all right, if you think it's close, let's say you had 2 beers and you were out for like 2 hours and you don't know. You're never really going to know. But if I've had a prior DWI and I think it's close, I am buying time before I produce a breath test. And that's just my opinion on it. A lot of lawyers will tell you different things, but what I'm trying to do in that situation is go.
Well, you're in the trenches, you know this stuff. Go ahead. Sorry.
Yeah, you buy time. You call a lawyer. You know, you tell them you don't want to do the breath test there. There's a 15-minute period where they need to observe you before you blow in the breath test to make sure that you haven't vomited, you got nothing in your mouth. Stuff like that can impact the result. So you have those 15 minutes. What you want to do is talk to a lawyer. Exercise as much of your right as you can to talk to a lawyer. Delay it. Buy yourself time. Hopefully by the time you actually blow into the breath test, you are under that 0.08 and you get to go home and without a criminal charge.
Eric, does that change if I know you do work in Illinois too, you're an Illinois lawyer and do criminal work over there. Does that change if you're over in Illinois, the scenario you just painted for us?
Yeah, the scenario is way different. For a refusal to blow in like St. Clair County or Madison County over in Edwardsville, they basically don't set aside your license suspension unless they see a reason to based on the evidence. So let's say you're real drunk and you got pulled over and it's a first DUI, you refuse to blow, but you're stumbling and you're falling on your face, you know, you're not going to be able to get out of that situation without a license suspension. But if you handle yourself well and you're respectful and you don't, you know, do the field sobriety and the walk and turn and all you have is a cop saying you smell like alcohol, you might be able to avoid your license getting suspended.
So tougher calls in Illinois depending on the jurisdiction and everything.
Definitely, it's definitely tougher, but you know, Illinois does it way differently. Everything is dealt with in the criminal court. So you're dealing with
is there a separate license suspension system, or is that in the criminal side?
It's separate, but it's handled in the same courtroom by the same prosecuting attorney, and so it's a little more straightforward in that sense. That being said, you know, I'm not exactly batting 1,000 in those. You know, it's about each case. A lot of people know you can refuse the breath test, but not a lot of people know that you can politely refuse any field sobriety. So if they ask you to do the walk and turn, a lot of people don't understand that you can refuse to do that, and there's a polite, appropriate, professional way of doing that. And I think that helps.
So should you do the field sobriety test short of the breathing?
I always say no, because there's only one person watching you do the field sobriety typically, and it's the person who pulled you over, and it's the person who thinks that you're intoxicated. And it's like a student grading their own paper. If you walk that walk and turn perfect, heel to toe perfect, this person is less inclined to write, you know, a paragraph about how sober you seem when they're trying to charge you with the DWI. I always tell my clients, by doing field sobriety, you're agreeing to allow them to write down clues of you being drunk, and regardless of how you perform. And
it doesn't matter how you do it. It matters what the officer writes.
It does. And, you know, it's you're not putting yourself in a great position by let's say you could do the alphabet perfectly, but at the end of the day, it's going to be that officer's word against yours and how you did it. And so.
How have you heard a million stories of clients saying, I did the field sobriety perfect and they wrote it up wrong, blah, blah, blah.
The story I hear most common, they wanted me to do it on an incline. It was cold outside. And you know what, honestly, I get that. I would be extremely nervous. So I might be shaking, you know, because if you don't understand, you know, as lawyers, I understand that, you know, you're kind of screwed already when you agree to do the field sobriety. Most people think if they do a perfect walk and turn, they're going home. So there's a lot on the line. I can imagine that they're shaking and not really able to perform as well as they'd like.